Good afternoon or good morning if you're joining us from the West Coast. This is Victoria Beal with the Ohio LTAP Center, and we are very pleased to have you with us for the second session of Tort Liability and Risk Management. I have with us my colleague from the West Virginia LTAP, their director, Ron Eck, and he will be presenting on the topic today as he did on this past Tuesday and will be for us 2 more times next week. So hopefully you'll be able to join us for all 4 of those sessions. Couple quick housekeeping items. If you would please find the question pod in your GoToWebinar panel and drop me a hi or hello so I know you found it. That's where we're going to be accepting questions throughout the webinar. We do not use the raised hand feature, so I appreciate the folks who are putting comments in there already. Thank you. The next thing is there are a couple of handouts in the handout pod. If you didn't download those yet, they are available for you. You can download them from that area. And then I believe that's all I have. So Ron, are you ready?
I'm ready.
Thanks.
Thank you, Victoria. Welcome, everyone. Welcome back to those of you that were here Tuesday. Welcome anew to those of you that were not. We're on day 2 of the session. And first, before we get into the new material, I wanted to answer some of the questions from last time. And one of them, I apologize for kind of assuming what the question was and not listening to Victoria. The question, and I answered with respect to, I think, a tort claim versus a criminal charge. And really the question was, is there an example of a sidewalk tort claim and a civil rights claim, an ADA claim? And this is an example from a number of years ago from Ocean City, Maryland. If any of you were in my ADA self-evaluation and transition plan class that Victoria hosted about a month or so ago, I used this example then, but I think it's applicable here as well. From Ocean City, Maryland, on the eastern shore of Chesapeake Bay here on the East Coast, an elderly woman fell from her wheelchair, or actually was catapulted from her wheelchair. What happened, and you don't see these anymore, fortunately, but back in the early days of ADA, one of the types of detectable warning surfaces was sort of a rubber or plastic kind of mat. And one of the issues with that is it tended to, the rubber or plastic would dry out and the mat would curl up. And that's exactly what happened here. She was going up or down the ramp and this detectable warning surface had curled up and somehow it got caught in the spokes of her wheelchair wheels and brought the wheelchair to a sudden stop. She was catapulted out of the chair and I believe may have broken both her arms or something like that. So she filed a tort claim seeking $750,000 in damages to compensate for her injuries and her medical expenses. But she also filed an ADA claim, a civil rights claim, alleging a failure to maintain the accessible features of the curb ramp. And so that's an example of a sidewalk tort claim and a civil rights claim, basically from the same cause or same source. We also had a question or a comment. Someone said, could you comment on what's called joint and several liability? And that is another legal term. I'm not really an expert on that, but it is a good point, and so I thought it deserves a mention here. This would be something that is addressed in each state's Tort Claims Act, and different states have different forms of this rule, if you will, or policy. But you can see it's basically a rule followed by some states in which 2 or more parties can be held independently liable for the full amount of a personal injury case or damages, regardless of their respective degrees of fault. And this is particularly tough for defendants such as road agencies, public agencies, or private entities like trucking companies in truck crashes, or other private entities that are deep pockets. So for example, this is just a simple hypothetical example. Let's say there's a crash on a roadway, maybe a vehicle driven by someone who's impaired. Maybe they're texting at the same time. So clearly there's some responsibility there. And let's say the vehicle hits some sort of maybe a defective joint in the pavement or something, such that the car bounces and the driver loses control. The car crosses the center line and hits another vehicle head on, and maybe the driver of that vehicle now is maybe paralyzed or permanently injured, and so they file a lawsuit. And maybe the jury awards the victim, maybe in the millions of dollars. If it's a young person who's, permanently injured, their life has basically been ruined, they may be awarded millions of dollars. But let's imagine too, in this case, let's say the driver of that vehicle, who I already said was impaired and was texting, let's say they have no insurance. Under joint and several liability, a road agency, well, let me back up. Let's say the jury put 95% of the responsibility on the driver for his negligence or her negligence, and let's say 5% on the road agency because there was maybe a defective joint. But under joint and several liability, the road agency may be responsible or would be responsible for that whole several million dollars of the award if the other party, if the other defendant driver, was unable to provide that. So you can see it's particularly tough on agencies. And I think we talked yesterday about tort reform, which was a big thing about 8 or 10 years ago. This was one of the targets of tort reform in many states, was to address this joint and several liability. And I know I don't know the situation all across the country, each state is different obviously, but I know a few states here in the Northeast region have ended up with now what's sort of a modified, or I guess they call it a hybrid joint and several liability, and it's not nearly as severe for defendants as this joint and several liability. Let's see, we also had a question about, if you remember my discussion of proximate cause, and was the breach of the duty a proximate cause of the crash. Someone asked about a case where, of course, the design sight line for sight distance is based on a 3.5 foot high driver eye height. And someone posed the question of, I guess, what if there was a crash, and what if the 3.5 foot sight line was blocked, but maybe from 4.5 feet where a driver in a big SUV might be seated, what would the situation be there? And I would say that would be one of those cases where you could argue there was a breach of the duty. The 3.5 foot high sight line was obstructed, but in that particular case, given the vehicle involved, the driver was 4.5 feet high, so should have been able to have adequate sight distance. So I would tend to argue that that breach of the duty was not the cause of the crash. And then one final question or comment. Someone asked about my example of the rock cut in Virginia that fell through the roof cab of a truck. And the comment was isn't that an act of God? And it could be. In fact, in the examples or in the case studies next week, I'll share with you a tree fall case where a tree fell on a vehicle and killed 3 of the occupants. And it was not like the East Coast had earlier this week where they may have had heavy rains and high winds. This was just a regular day. There was no wind. There hadn't been any rain to speak of for any period of time. The tree just fell on the vehicle. And in that case, as you'll see, the road agency is arguing, or did argue, that that was really an act of God. They had no way to foresee that what appeared to be a healthy tree would fall at that time. But in the case of my example, since it was a rock cut through some sort of ridge or mountain area, so it was created by people or by humans, and I think it's probably foreseeable that once you make a cut through a mountain or a ridge or something like that, that given weathering and freeze thaw and so forth, and gravity, that over time, some of that rock is going to fracture or crack and probably fall toward the roadway. So I think in that case, it probably would be hard to make an act of God claim. And particularly in that case, I think I mentioned there was a fallen rock warning sign, which also suggests that the road agency knew that there was a problem at that location. But good questions, and hope keep them coming today. Any questions you have, just put them in the Q&A box. Today, I'd like to talk about the tort liability process and what's involved there, and particularly what role might you all as, say, road agency or public works personnel play in that process. The whole thing starts with what's called the complaint, or I believe some states call it a petition, but a complaint or petition, that sort of kicks off the process. This is the legal document that would be served on the defendants that basically says you're being sued or your agency is being sued, and it lays out what the claims are. I don't know if any of you have ever seen one. Probably have no need to see one, but if you see one or read one, it can be pretty intimidating. It can be pretty thick, and almost anything that could be wrong with a road, the plaintiff may allege to make sure they cover all their bases as the case proceeds. So what I did was I cut and pasted portions of an actual complaint onto the next slide. And I apologize for the small print, but I thought rather than me retype it, I wanted you to see the actual words and everything verbatim of what the plaintiff was claiming. So let me tell you a little bit about it, then we'll look at the complaint. This was a 2-vehicle fatal crash that involved a loss of control on an isolated patch of water or ice. This was in this general part of the country, I'll say the upper Ohio Valley part of the United States. It was in late November. So as those of you familiar with this part of the country know, during the overnight hours, it can very easily, temperatures can drop below freezing during that time. And about a week before this crash, there had been, for almost a week, had been very heavy rain, probably on the order of 6 or 7 or 8 inches of rain within a week, which for this part of the country, that's obviously significant. And so there was a lot of runoff off the hillsides. And in this case, in addition to coming off the hillsides, there was also water coming out of 2 driveways that had been constructed along this road. But what made these driveways interesting was that they were constructed about 20 years before, but they had never been finished. So they were graded and sort of sodded, but there was no asphalt or concrete surface. And what that night, basically the roads were dry, but there was a lot of water running down the hillside in the drainage channel. But near the bottom of a grade, a long grade, a drainage inlet was totally clogged. I mean, it was clogged so much that if you can picture it, the earth was actually, or sediment was actually mounded up within this inlet. And that created an obstruction to the drainage channel such that the water was directed across the road. So you had water running across the road, actually in a curve at night, and temperatures were sub-freezing. A woman probably in her 50s was heading sort of up the hill. She encountered this unexpected ice patch, lost control, and the vehicle started spinning. It crossed the center line and was struck by a truck coming the other way, and she was killed in the crash. Her husband filed a lawsuit, and what you see here are portions of the actual complaint that was filed in that case. I've redacted, obviously, identifying information, but I'll call your attention to a few things. Let me get my pointer here. Notice I'm just showing you item 37. So there's 36 items or points before this, and those would be things like laying out who owns the road, who owns the private property that the driveways were involved with, why is this particular county where this lawsuit was filed the appropriate venue for the case, and lay out that, you know, this driver was on the roadway, on a dry roadway, driving carefully when she suddenly encountered this unexpected slippery condition, you know, written in that sort of language. So there'd be 36 points before that, and this is then 37. And so notice as I read this, if you recall those 4 points we talked about last time on Tuesday about the 4 things a plaintiff has to prove to get their case to the courtroom. Notice how the plaintiff's attorneys will try to couch their wording in that same sort of format. So it says the collision and the resulting injuries and death of the decedent occurred as a direct and proximate result of the negligence and carelessness of the defendant. The defendant is a state DOT, generally and in the following particulars. So notice they're saying that the crash was a direct cause of the negligence of the DOT. Now remember, at this point, this is sort of a claim. This is a complaint. This has not been proven yet. That's what's going to happen in the lawsuit as they gather evidence, witnesses testify, and that sort of thing. So at this point, this is just a claim, but that's what they're claiming, is that there was this causal relationship between the defect and the crash and the injuries. And notice, you see, these don't go in consecutive order here. Again, I just actually cut and pasted these out of the complaint. But I should tell you, notice it starts with lowercase a here and actually went through lowercase z and then started with lowercase a, b, c, c. And actually it went through in the whole document, which I saw no reason to produce that here, but it went from A through TT. So what's that, 40 or 45 specific items were in that complaint directed at the road agency. And I've just put 6 or 7 of them here for us to discuss. But notice the first one, failing to properly inspect and maintain and clean state route, whatever. Remember, we talked last time about one of the duties of a road agency is to inspect and know the condition of the roadway. Next one is failing to remove debris and sediment from an inlet located on the shoulder of this state route, causing excess water to divert onto the roadway. So that's really sort of the crux of the matter there, what they're claiming, that a road agency should not be allowing water to be directed onto the roadway. Next one, by failing to correct defects in the drainage system that are visible to the variety of DOT personnel. Personally, I think that's a little awkwardly worded, but basically what they're trying to say is that these defects were visible or should have been visible to DOT employees, and therefore they were on notice about the defect. That's basically that's my engineering interpretation of the legal terminology there. Next one, by failing to conduct a competent roadway inspection to detect and identify deficiencies. So they're alleging a failure to inspect. Notice F here, by failing to train maintenance personnel in basic knowledge of which types of drainage from abutting property to the highway are permissible to encourage reports of any improper drainage activity. So notice this failure to train. This is just my personal perception, but when I started doing this sort of work like 35, 40 years ago, I rarely saw that in a complaint. But now I see it almost in every complaint that's filed against a road agency. So the plaintiff's attorneys, recognize that part of being a reasonable road agency at any level, whether it's state or county or city or village, part of a reasonable road agency is making sure your employees are trained. And in this case, the plaintiff is alleging that there was a failure to properly train. And notice how they word this here, to encourage reports of improper drainage activity. I think, as I interpret that, that also means this idea of making sure the road employees are able to identify drainage deficiencies as they drive the roadway, and then to report those deficiencies to their supervisor or whoever the appropriate party might be. And then K here, by allowing subsurface water from below the pavement to seep out of cracks and joints and onto the roadway. So in addition to surface water, they're alleging that subsurface water was seeping out of cracks and joints and flowing onto the roadway, and that was also freezing. And this is part of how this whole thing is played, sort of, if you will, because had the complaint maybe just addressed surface water, one of the defenses of the road agency might be, well, most of that water actually was subsurface water, so you haven't identified the problem properly. So again, to sort of cover all their bases, notice the plaintiff is saying not only was it surface water, but it was also subsurface water. And then with regard to the behavior of the DOT with respect to the property owner and the driveway, notice they say or claim by allowing defendant Smith or Jones or whoever it might be to discharge water onto the highway right-of-way in violation of the permit issued by the defendant DOT on September 27th, 1997. And that permit, of course, would be the driveway permit or occupancy permit, whatever it's called in your state. But they're saying the DOT allowed the property owner to discharge water onto the roadway right-of-way in violation of that permit. So hopefully that gives you a feel for sort of the flavor of how the plaintiff's theories would be couched in the sense of a complaint. And then the defendants would have a chance to respond to that in what's called their answer to the complaint. But basically, once that stuff is filed, then the nitty-gritty of the lawsuit begins in terms of deposing witnesses and gathering information. And that process is called the discovery process. All parties furnish information. And one thing about the legal system that we have here in the United States, all parties have to furnish all the information they have, even if it's detrimental to their case. In fact, I think, as I've been told, if an attorney would be found to withhold information because it's detrimental to their case, that's probably a serious unethical breach as an attorney might be involved with. They probably lose their law license, at least temporarily, if not permanently. So all parties have to furnish the information they have available. And this process can go on for, I guess it could be as short as a few months, but oftentimes it may be 2 or 3 or more years in duration as this information gathering proceeds. There's 3 key elements where the road agency personnel may be involved, and there's a couple more legal terms here, something called interrogatories, production of documents, and deposition. So let's look at each of these, and maybe some of you have been involved in these. I know about a third of you, I think, last time had given depositions. Interrogatories. These are basically questions asked in writing by one party to the suit of other parties in the suit, and they're answered in writing. And notice they're answered in writing under oath. So the defendant is, or the plaintiff, whoever answers them, is sworn that you're sworn to tell the truth, that these are, in fact, truthful responses, accurate responses. And let's take the case of that truck crash. If you remember, I showed you the edge of pavement drop off with the coal truck, the fatal crash where it struck a Chevrolet Blazer. In that case, one of the defendants was the state DOT. So maybe the plaintiff's interrogatories to the state DOT might be, when was that section of road last resurfaced? Another question might be, when was the shoulder on that road last bladed or maintained? Another question might be, identify the crew foreman and crew members who are responsible for that section of the state highway. So those are typical sort of interrogatory questions. And obviously, the agency attorneys typically don't know the answers to those questions. So they have to go to folks like you who are in the field or involved in the decision making and have the records to answer those questions. So I'm sure probably many of you have helped your agency counsel answer interrogatories. And if some of you haven't, it's something that certainly could very well happen in your career. You may be asked to help answer these questions. And remember, the response is under oath. So we're saying that these are honest, and accurate, or truthful and accurate responses. A related discovery item is what's called production of documents. And as the name implies, here the party is requesting documents. that are relevant to the lawsuit. And I just put a very short list here. Things like construction drawings. If it's a work zone case, probably field inspector diaries, those sorts of things. Maintenance records, sign installation orders, all sorts of things like
Hey,
that.
Ron, this is
Yeah,
Victoria. Not to interrupt you here, but I wanted to add that we've even had attorneys call and request copies of our training manuals at times.
that's a
If
good
they
point. Yeah,
have,
I should add, yes, that's very true. That's correct.
so, I mean, and I think sometimes it's just to see if there was a lack of training, but
That's
you know, they do request right down to the training manual. And I've got a couple questions for you that are here in the
sure.
box. I hope you don't mind if I break in, but
No, please.
um, the first one, the person said they would be interested to hear a bit of expansion on the idea of what is reasonable and acceptable to do after an incident without causing liability problems, such as fixing vegetation, sight distance blockages, dirty signs, etc.
I would say, I would probably do all of the above if you see deficiencies after a crash, because if you recall, one of the last things we talked about last time was this idea or legal concept of subsequent remedial measures, so that those measures you may do after the fact or after a crash to maybe remedy deficiencies that might have existed at the time of the crash, those cannot be admissible as evidence to show negligence or that sort of thing in a lawsuit. They might be admissible if, say, the road agency in their defense is saying it was not feasible for us to do that, and then it turns out actually they did it. In that case, a judge would probably allow those measures to be, that information to be given to the jury. But in the typical case, that information is not admissible in court. So I would say you should, just in the interest of public safety, you should not hesitate to do those things like trim vegetation or patch a pothole or clean a sign, whatever the issue might be, or replace a sign. Because think about it, if another crash would occur a week or two or a month later and you've not done anything, now that if there'd be a second plaintiff from that second crash, now they have an even better case, because now they can point to the first crash and say, hey, you were on notice that there was a crash here previously and the agency didn't do anything about it. So my advice is, yeah, don't hesitate to make those improvements or corrective actions.
And would you apply that even to like major structural changes? That's an extra follow-up question they put in.
Oh, that's a good question.
I know usually those don't move as quickly as going out and trimming the bushes,
Right.
but would that fall even under the exception that we have for doing road safety audits, where that road safety audit report can't be used as evidence?
That's right. Yeah. Yeah, for the larger, what would you call more capital improvement type of things, that's a different case there. In fact, I'm not sure we'll have time to do it Thursday, but one of the case studies I was going to present, or that I have, is a case where there was a T-bone crash at a stop controlled intersection. The stem of the T had to stop and the top of the T was through. And there apparently had been a crash history at that intersection. After the crash, the road agency installed rumble strips on the approach to the stop sign. And one of the issues in the case, or actually one of their defenses in the case, was that we don't install stop sign or rumble strips on stop sign approaches. But that came back to sort of haunt them, because the judge said, well, you can't really argue we don't normally install rumble strips on stop signs, but in this case, after the fact, you did. So he was going to allow the jury to be informed that rumble strips were installed. So, yeah, that's a good question about the larger scale improvements. I guess I hate to dodge the question, but I think the answer probably is it depends. And it is, as Victoria said, it is longer term. I mean, if something is in the works for that location. Maybe after the crash, you want to accelerate it and get it implemented sooner. I mean, I think that would be appropriate.
Okay. One more quick question, and then we'll let you go back to it. What if the inspection is once every 6 months? So if the rain occurred the night before, how was the agency responsible?
Oh, again, the answer sort of is it depends, but I would say, and this is just Ron's personal thinking, based on my experience, I would say in general, inspecting a road probably once every 6 months is probably too great an interval to show that you have a reasonable knowledge of your road system. The exception might be if it's some very low volume road with like 20 vehicles a day or something on it, in the outskirts of your state or your county or whatever it might be. But even then, to me, 6 months is probably too great a period of time between inspections. Even for lower volume roads, you probably at least every month or so, you'd probably want to get out on those roads and at least take a look at them by some competent, knowledgeable inspection person. Those are my thoughts on that one.
Thank you.
Thank you all. Good questions. And the third item, and many of you already have been involved in this, and if not, chances are if you stay in public works and the roadway field very long, you'll probably have to at some point give a deposition. And so that's kind of the third element of this discovery process where road agency or public works people might be involved or can be involved. If you're not familiar, depositions are basically questions asked by the attorney or attorneys orally. So I mean, sort of face to face, or I guess these days might be by Zoom or GoToMeeting or something like that. But they're asked orally and they're responded to orally and under oath. So you're sworn to tell the truth. And a key thing about the deposition is that the other person that's in the room is a court reporter, and he or she is taking down every word that's said. So really, if you ever give a deposition, you should treat it just like you're in the courtroom. It's serious business, even though you can sort of let your guard down sometimes, because especially if it's in the plaintiff's attorney's office, say in a big city somewhere like Columbus or Pittsburgh or Cleveland or Chicago, they may have a big fancy office with a nice conference room, and one end of the conference room might be a whole stand of coffee and tea and water and soft drinks and juice and pastries. You can almost feel like you're in the corporate suite at a college football or NFL football game. And that's why I say it's easy to sort of let your guard down, but you need to recognize that it's a serious business, and it's just the same as if you were in the courtroom. As I say there in the last bullet, a deposition transcript, which is after you would testify, the court reporter in the weeks or a month or so after your deposition would type up the transcript of that proceedings, and it would form a little booklet, sometimes spiral bound or stapled. That is called your deposition transcript, and that has two uses in the legal process or in the discovery process. One is for what's called discovery. That means so all the parties in the lawsuit know what you don't know, and what you're going to say at trial. The truth is, really, when a trial takes place, everybody basically knows, everybody meaning the parties involved, know who the witnesses are going to be, what they're going to say, what evidence or exhibits are going to be introduced. And the only surprises really would be if somebody sort of changes their testimony. The difference is, of course, in the courtroom, you're presenting all this information, evidence and testimony in front of the jury, and the jury is weighing all of that. So that's an important use of the deposition transcript, is so people know what you're going to say in the courtroom. But another and very important use of a deposition transcript is for what's called impeachment. And this is the legal meaning of impeachment, which is different from the, let's say, the political meaning. Here, impeachment means attacking the credibility of a witness. And let me give you a simple example, and I'll use myself as the person here. But let's imagine I'm a young crew foreman for, I don't know, say a county road department, and we installed a culvert that maybe later failed and led to some damage or injury, and that's resulted in a lawsuit. So the plaintiff's attorney would certainly want to take my deposition. And let's say I will tell him in deposition or tell her that I installed the culvert on, say, August 15th. But then after the fact, I realized that actually it was October 15th. If that would ever happen, if you give a deposition and you realize after the fact that you made an honest mistake in terms of recollecting a date or something, the first thing you should do is notify your attorney, and they'll probably take a new short deposition so you can correct your testimony on the record. But let's say I'm, as I said, I'm a young guy, I'm apprehensive about this whole process, I'm kind of intimidated by all this. So let's say I don't say anything to the attorney, to my attorney after the deposition. And then maybe 6 months later, this case goes to trial. And I'm in the courtroom on the witness stand with the judge there and the jury. And it's the same attorney who took my deposition. And he or she is asking me the same questions that they asked in the deposition. And so he might say, or she might say, Mr. Eck, when did you install this culvert? So I think to myself, you know, in deposition, I said it was August 15th, but I know now that it was October 15th. So I say October 15th. Well, probably what that attorney would do would probably go for the, you all probably seen in TV and films, the table where the attorneys put all their legal paperwork and documents and everything that they're using in the case. He or she would probably head for that table, find my deposition transcript, turn around and come toward me and probably would say, Your Honor, may I approach the witness? And he or she would bring my transcript to me and probably say something like, Mr. Eck, when I took your deposition 6 months ago, you said you installed the culvert on August 15th. Now you're telling this jury you installed it on October 15th. Were you lying then or are you lying now? And that's what I mean by impeachment, because now the jury thinks that I'm just a darn liar and they probably can't believe anything that I've said before or after that point. And so I've sort of been destroyed as a witness. So that's one of the key uses of a deposition, and we need to be aware of that. So that's why the next few slides are just some of my tips for giving a deposition. And those of you that have given depositions, if you have additional tips that you like, please feel free to put them in the Q&A box, lessons you've learned. But for those of you who may not have given a deposition yet, hopefully this will maybe make it a little bit less stressful or a little bit easier to prepare for. They're in no particular order except the first one. I think the first one should be the first most important item on the list, and that is when you're testifying, always tell the truth. If you don't tell the truth, you open yourself up to perjury charges and that sort of thing, so always tell the truth. Listen carefully. It may sound strange because a deposition is you're testifying, you're speaking, but to me, a key part of the deposition is the listening skills. And I'll use myself as a good example of what not to do. Remember, I answered the question yesterday about a tort claim versus a civil rights claim. I kind of anticipated what the question was and assumed what the question was without listening properly. And so I really answered the wrong question. That's a good example of what not to do. You need to listen carefully. Don't anticipate what you think the attorney's asking, or don't assume what they're asking. Let them get the whole question out, then think about it, then answer the question. Also, don't answer a question that you don't clearly hear or understand. In fact, probably one of the first questions the plaintiff's attorney will ask you is to agree that if you answer a question, it means that you've heard it and understand it. And so you need to make sure, it's critical that you hear and understand every question. Don't be embarrassed to say, can you repeat the question? Or can you rephrase the question? In fact, I think one time I must have probably asked the attorney probably 7 times if they could restate the question, because we were just on different wavelengths, not understanding each other. But I felt I wasn't going to answer that question until I was clear about what he or she was asking. Also, don't guess. You can estimate, but if you estimate, make sure you make that part of your response. Like, I would estimate that it was 17 feet or something like that. For example, if an attorney happened to ask all of you now, what's the size of the table that Ron is sitting at in his home office in Morgantown? I don't believe any of you have been in my home office here, so you don't know. You probably can't even estimate. That would be a guess. So the proper response would be, I don't know. So don't guess. It is okay to say, I don't know, or I don't remember, if that's the honest answer. Sometimes I'll talk to people and they'll say, well, I don't want to say I don't know because that's going to reflect poorly on me and the agency. Don't worry about that. It's going to reflect more poorly if you sort of make up some answers or speculate. If you don't know or can't remember, just say so. It doesn't reflect poorly on you or your agency. Or maybe if they ask you about an invoice or something, the date on an invoice maybe, and you know it's in your file back at your workplace, but you can't remember the date, just say that. You can say that's in our file back in the workplace, but I just can't remember. And then probably what will happen is your agency counsel who'll be there next to you, he or she will probably say to the plaintiff's attorney, if you'll send me a letter after the deposition requesting that invoice, we'll be sure to get that to you, because they're entitled to that information. But a depo is not a memory test. You're not expected to remember everything in your life or even everything in your work career. But if you remember where it is, or if it's filed somewhere, that's the answer. And so the other side can get that information at some point. Also, sometimes during a deposition, the plaintiff's attorney may show you a document. Always be sure to read and examine it carefully. My experience has been, by far, most of the attorneys are honest and above board, but sometimes they may delete a page from a document or cut and paste something so it's not the same document that you might be familiar with. So that's why it's important to read it carefully. And if you need some time to do that, again, don't feel bad. I've heard some people will say, well, I don't want to keep these folks, these high-priced attorneys, waiting while I read this document. Don't worry about it. The deposition's really about you, and you want to make sure you testify accurately and honestly and so forth. So if it takes you a few minutes to read it, don't worry about it. This next one sounds sort of obvious, but I'm still amazed at how many people don't do this. In fact, I didn't even do it in that question I mentioned, and that is answer the question that was asked. Don't volunteer information. Sometimes people may, again, sort of assume or anticipate a question and not answer the question that was asked. And by doing that, they may be giving the opposing attorney information that they can use against the individual or against the agency. So don't volunteer information. Answer the question completely and honestly, but don't volunteer information. Something else a little bit harder to do, maybe take some experience, but wait a second or so before you respond to give your attorney a chance to object. He or she may want to say, I object to that question. And so it's important to wait a second or so between the attorney, the plaintiff's attorney, finishing their question and when you respond. And if an attorney objects to a question, don't worry about it. What they're doing is what they call protecting the record. Again, I've talked to some people who have given depositions and they say, well, maybe I shouldn't have answered that way, because then they started objecting. Again, don't worry, it's not about you, it's not about your answer, they're just protecting the record. I've been in a few depositions, it doesn't happen often, but sometimes your attorney may instruct you not to answer a question. And that's when sort of a real argument can begin. And again, it's between the attorneys. And again, it's nothing to do with you. A couple of depositions I've been in, the attorneys have actually called the judge on the telephone while I was in the room to get a ruling on whether or not, the witness could be allowed to answer a certain question or not. If that would happen to you, my advice would be, hopefully the attorneys would ask you to leave the room. But if they don't, you should just excuse yourself, because you don't really, to me, having or being part of that conversation just sort of clutters your mind, and you need to be focused on what you're going to testify about. And you must answer every question, even those that are objected to. The only time you wouldn't answer is if your attorney, your agency attorney, instructs you not to answer the question. Learn to be comfortable with dead air. Dead air is like what the media refers to as sort of silence when no one is speaking. And would you agree, in our culture, dead air is not a good thing. People tend to get uncomfortable. And when there's too much dead air, sometimes people will just start talking. And that's what a good plaintiff's attorney hopes you'll do. So sometimes a good plaintiff's attorney won't say anything for a while to create that dead air, and they're hoping that you'll feel uncomfortable and start speaking. So don't fall for that trick. That's why I say learn to be comfortable with dead air. Once you're sworn in by the court reporter, the only speaking that you do should be in response to a question. Don't just start speaking sort of contemporaneously with no question on the table. Try to be humble, keep your cool. Usually this is not an issue at a deposition as much as at trial. At trial, a good plaintiff's attorney will try to get the witness, riled up, get them to lose their temper, get them sort of explode, emotionally with temper tantrum or something. Typically that doesn't happen at a deposition. But if you find yourself, getting worked up or something, or getting aggravated just from the way the attorney's asking the questions or something like that, my advice would be to ask for a break. And that's your right in a deposition. The deponent, as they call the person being deposed, the deponent, you can ask for a break at any time, and you don't have to give a reason. You may need to go to the restroom. You may need a cup of coffee. You may just want to, maybe, as I said, maybe you're getting hot under the collar and you think, hey, I just need to walk around outside for a few minutes to cool off. You just say, can I have a 10-minute break? You don't need to give a reason. Anytime during the deposition, you're entitled to a break. The only exception would be if there's a question on the table, you need to answer the question before the break begins. But attorneys are used to breaks. If you can imagine when plaintiffs, the deposition of plaintiffs or witnesses are being taken, especially in a fatal crash or something, or family members being deposed, it can become very emotional if you're talking about, say, your child who was maybe killed in the crash. And so breaks are quite common during a deposition just because people need time to gather themselves together, if you will. So don't hesitate to ask for a break. And related to that, as I say here, don't take it personally. The attorneys are doing their job, you're doing your job. Just stick to the facts and don't take it personally. At the end of the deposition, you'll be asked one final question, and it could be asked by the plaintiff's attorney, it could be asked by your attorney, it could be asked by the court reporter. And the question is, do you want to read or waive? Waive meaning, or being W-A-I-V-E. And what that means is everyone who gives a deposition has the right to read that deposition to see if there's any errors in it. So if you say read, that means you're going to read the deposition and complete what's called an errata sheet, where if there's any errors, you can correct those errors and then sign, that sheet would be signed and notarized. But if you waive reading, then you give up that right to correct your deposition. And this is the person that gives the deposition, it's their decision. You can rely on your attorney as well, but really it's your decision. My advice would be to read your deposition, because if nothing else, it gives you a copy of the transcript. So you'll you can always have a copy of that transcript to know, what you said, and which is especially important if the case goes to trial. You want to read that the night before you would testify at trial to be familiar with what you said during the deposition. Now you can correct it, but you can't really change. Like if you answered no to a couple questions, you can't really change it to answer yes. I mean, I guess you can, but usually my experience has been that will cause the opposing attorneys to obviously sort of a flag goes up, and they'll probably want to take your deposition again. But there may be other types of errors that the court reporter makes that are not as significant as that, and that you have the right to correct those. And then probably my final bit of advice is to prepare ahead of time with your agency attorney. And I know, all of us are busy, attorneys are busy. It's sometimes tough to schedule time, but you should really try to, as best you can, see if you can sit down, ideally in person, but second best would be, say, over the telephone with your attorney, maybe a day or two before the deposition, just to review, what you should bring to the room, what you should wear, what type of questions you might be asked, a little bit maybe about the demeanor of the attorney. I remember one of the first depositions I gave, and of course I testify as kind of the independent expert. I'm not an employee of an agency or the plaintiff, but I was giving a deposition and I answered the question truthfully and honestly, and the attorney suddenly pounded the table with his fist. He said, "You expect me to believe that? How can anybody believe that?" And he was trying to really, I think, bully me or intimidate me to change my response, which I did not do. Then he actually stood up and sort of hovered over me, which again, I thought personally was maybe inappropriate, but that's what he was doing. And then finally then the attorneys got into a shouting match, and finally he calmed down and we proceeded. And after the deposition, the attorney that retained me said, "I probably should have told you about Kevin. He does that all the time." And I thought, yeah, that would have been nice if I'd known about that ahead of time, so I wouldn't have been so broadsided by that outburst. So there may be those kind of, personality traits or something that it might be helpful to know about in terms of the opposing attorney. But otherwise, as I think I said before, maybe just get a good night's sleep before the deposition. Don't worry about it too much. After you give it, the sun's going to come up the next morning and life will go on. It's just part of this discovery process. So I think I'll stop there. Victoria, any questions come in, or anybody add any tips to the Q&A?
Actually, we had 3 tips that I shared out, but I'll read them off. One is lesson from giving a deposition: give the shortest answer you can that is truthful. Do not volunteer any information that is not specifically asked. That was one of them. The next one, next one said, don't answer more than the question asked. Don't have diarrhea of the mouth.
Yeah.
So, and the last one that came in said, in one deposition, the attorney kept asking me to answer questions, re numerical standards. I responded with, as an engineer, I don't work from memory. If you'd like me to look up the answer in the standard manual, I can do that. So excellent tips there. And I'll add one more just from my own experience, that sometimes attorneys phrase questions to get an answer that would potentially make you look bad as the person who's testifying. And it's usually in that person's gut instinct to try to make themselves not look bad. So, answer it to the best of your ability, but it really is the other attorney's job, your attorney, to then on redirect, ask the additional questions to correct what, may or may not have come out in that question that the first attorney asked. So don't feel bad if your answer leaves you, looking bad, because it's really your attorney's spot then to ask the additional questions to get the rest of the information out. So, and a lot of times people will try to add that additional information in, and the primary attorney will use it as a credibility issue in front of the jury. So it's just another item that I've learned through the years.
Yeah, that's a very good tip. Yeah, it reminds me too, and it's related to that, I think, Victoria, is that I think sometimes I've talked to road agency employees who are giving a deposition, and they're worried that sort of if they give a wrong answer or, like you're saying, to a question where they might look bad, they may think that the whole deposition then becomes, a loss or a disaster. But that really what you have to do, as you're sort of saying, is consider the deposition in whole and in total, and don't worry about your response to one question sort of losing the case or anything like that, because it needs to be taken as a whole. Would you agree with that as an attorney, Victoria?
I would, absolutely. So, and there's no other comments in the question box right now.
Okay, thanks for the good questions and the good tips as well. Proceeding after the discovery process wraps up, there's something called a pretrial hearing, and this may be a month or 2 or 3 before the trial, but it's basically a meeting between the judge and the involved attorneys. And some judges may insist that, say, somebody from maybe the road agency or an insurance company, depending who the parties are, may be there that has some authority, to offer up some money in terms of a settlement, because what the judges try to do at this point is to get the parties to settle. And as I say there, most claims are settled at this point. I've known it for many years. He retired a couple years ago, but I've known one of the deputy attorney generals for the Commonwealth of Pennsylvania, their Pittsburgh office, and he defended the Pennsylvania DOT, oh boy, probably 30 or 40 years during his career. And as he was getting to retire a couple years ago, getting ready to retire, he sort of, tabulated the cases that he was involved with to kind of see where he stood in terms of the types of cases and that sort of thing. But anyway, he told me that over his 30 or 40-year career in the road business defending a state DOT, I think it was 96.5 of the cases that he was involved with settled before trial. So the point is, the cases that go to trial are really rare cases, at least in most states in the legal system. Most claims do settle prior to trial. But if the case does go to trial, this is what would happen. There'd be jury selection. Of course, the plaintiff and then the defendant would make their opening statements. The plaintiff and then the defendant present their cases, their witnesses, their evidence, and so forth. Then each makes closing arguments. The judge gives instructions to the jury, and then the jury renders a verdict. If one or more of the parties in the suit feels that the judge made an inappropriate ruling or some other irregularity in the case, they of course have the right to appeal. And depending what would happen at that appellate court, the case may stand, or the verdict may stand, or there may need to be a new trial. But that's the process. And I think most of us are probably familiar with that, if nothing else, from TV or films. The jury's decision is usually 2 parts: liability, or the negligence part, proportioning the responsibility, and then the damages, or the award portion. Typically, these are probably tried together jointly, but there can be what's called a bifurcated trial where they're tried separately. For example, the liability trial would go first, and then if the defendants would be found responsible, then there would be a second trial where the awards would be determined, or the award, I should say, to the plaintiff would be determined. I want to say a few words about what I call personal matters. What if you are sued personally? And again, remember, I'm an engineer, not an attorney. This comes from my discussions with attorneys and is not meant to be legal advice. But what happens if you're sued personally? I mean, it's kind of scary, right? If a process server comes to your workplace or to your home delivering the complaint that's announcing you're being sued, you might wonder, am I going to lose my house? Am I going to lose everything? So what about that sort of situation? Fortunately, the news is really good, or the situation is really good. You shouldn't have to worry unless you would be found acting in one of the following ways: with gross negligence, or indifference to public safety, or utter disregard for public safety, those sorts of things. But the point is, those things are really almost crimes. and typically don't take place in the workplace. And let me give a simple example. This comes from my colleague Peter, the attorney in Virginia, that he uses when he teaches the class, the in-person class with me. Imagine you're driving an agency vehicle, and probably many of you, maybe all of you, do drive an agency vehicle. And imagine you drive that vehicle into an intersection and there's a collision. Crashes happen. That's why we have insurance. One or more parties may have made an error. There may have been a problem with the signal system or who knows what, but a crash may have happened. Errors may have occurred. That, to me, those wouldn't fall into these categories. But now imagine you're in that same agency vehicle approaching the same intersection, and just before you enter the intersection, you put your hands across your face to blind yourself, cover your eyes, and at the same time you mash the accelerator to the floor. And now imagine there's a crash. Is that a simple error on the part of one or more of the individuals involved? I would argue no. In fact, that might be considered utter disregard to public safety or indifference to public safety. But do you see the difference? To me, the difference is like night and day. That first case, you know, as drivers, as humans, we may make an error, or somebody or the other party makes an error, and there may be a crash. But in the second case that I presented to you, that wasn't an error. That's sort of a total disregard for public safety. And some of the cases I've been involved with over the years, I mean, I've seen engineers make really serious blunders that somebody said, wow, isn't that gross negligence? But the judge determined that it was a bad mistake, but it wasn't gross negligence. So to be gross negligence, it really has to be serious and are almost criminal. And again, just normal mistakes that we make in our day-to-day work, you shouldn't have to worry about. Wanted to say a few words about advice on handling contacts, both formal and informal. Formal contacts might be things like a subpoena. Maybe you get a subpoena at your workplace. Here, my advice would be, as soon as you can, get that to your agency legal counsel, and they'll do the work, but it's important that they know you received a subpoena. So don't put it, you know, on your desk or somewhere or in your dashboard, depending where you work, and say, well, I'll give it to them, you know, tomorrow or whatever. Try to get it to them as soon as possible. May also, of course, the public may also make Freedom of Information Act requests, where they may be requesting documents or answers to certain questions, and you may be asked perhaps by, if not legal counsel, but by your agency's FOIA person to help respond to those. Informal contacts, one of which is email. I think a critical thing to remember is that email is a document, not a conversation. So if there's something you wouldn't want to put in writing, don't put it in an email or a text for that matter. If you're concerned, have concerns about, say, the safety of a certain location, maybe the best thing to do is pick up the phone and call your colleague or call the other party, or depending on your workplace, walk down the hall or walk to the other side of the shop or the maintenance yard and have a conversation, but don't put it in an email or a text message. And even if you think you've deleted a text or an email, it is out there in the cloud and it can be requested. In fact, that's one of the things agencies request now, or plaintiffs, I should say, request as part of their request for production of documents, is they'll ask for all emails, all agency emails related to this project or this location. And that works both ways, because one of the first things probably a road agency attorney would ask for of the plaintiff is they'll ask for all their social media passwords so that you can get in there and look at what they might be saying on Facebook or Twitter or something else. So the digital world is now obviously a big part of the legal system here in the matter of tort claims involving roadways. And I wanted to say too, a few words, maybe you get phone calls, or those of you that your job may be, you know, out on the roadway, boots on the ground, you may actually have people sort of stop by while you're out on the roadway. And what they might be doing is kind of pumping for information. So my advice would be, of course, ask them if they have permission from your agency's legal counsel to talk, which of course they don't. If they wanted to get permission from your legal counsel, they wouldn't get that permission. But what they're hoping is that they can get some information from you that can be used to help them make their case without going through the legal process. But when we do that, it ends up hurting us and the agency in the long run, because they'll probably twist that information into something that you didn't really say. And of course, there's no witnesses, there's no record of what you said. So, I mean, be cordial with them. You don't have to be unfriendly or nasty, but just really don't say anything about the information that they're seeking or about the crash or the incident that they're talking about. And probably the best advice is refer them to your agency's legal department or attorneys. So with that, let's look at some common problem areas in the time we have left. And these are all photographs. In the interest of keeping the file size reasonable, you all were not provided with these, but these are some common problem areas where tort claims result when there are crashes. And they're in no particular order, but the first one I have here is design. Actually, this is a West Virginia roadway. It's one of those roadways I was talking about yesterday. This road was probably never really designed. It evolved from probably animal paths. But notice, you can see the issue here is there's not adequate sight distance over this crest curve. And in fact, reflective of that is, notice all these tire marks. This is a form of risk management. I like to call this reading the road. If you look at any section of road in the country, you'll find marks of various sorts. You'll find skid marks, you'll find yaw marks, you'll find scrapes and gouges. And that's because things happen along our roadways. But if you find a collection or a cluster of those marks at a specific location, that's probably an indication, like here, that motorists are having difficulty negotiating a section of road. And here it's easy to see what the problem is, right? Traffic probably backs up on the other side of this crest here. And about at this point, motorists see that and make a panic brake application. So that's the physical indication that there's some problems with that section of road, or a deficient sight distance. And this is, of course, probably difficult and not low cost to correct that. It probably means regrading the road and talking about a lot of money. But we might keep that sort of thing in mind if we're setting up a work zone in this area, and make sure that the flagger and our advanced warning signs are here before the crest rather than on the other side of that crest. Cross section and cross slopes, another area where design is often the issue. Related to cross slope, super elevation. This is Pennsylvania, but this is another one of those roads I mentioned yesterday or Tuesday that was never designed. But if you look what happened, it has what we call a negative or adverse super elevation. And this is a serious design deficiency. And this location, unfortunately, was a perfect storm of factors. We had a young driver driving a truck loaded with water for a hydraulic fracturing operation at a gas well. His previous experience, no disrespect to him, but his previous experience had been on the Gulf Coast in Louisiana and Texas, so he'd never really driven in hilly or mountainous terrain before, so had no idea really about gearing down for grades and that sort of thing, and had never been on this road. There's no advanced warning sign. The only thing that exists here is a yellow and black left arrow. So he's probably traveling too fast. Notice the curve is banked the wrong way. You can't see it, but there's a bleeding or slippery pavement here. We'll talk about that in a few minutes. And ultimately what happened, you can see the vehicle ran off the road, overturned, and the driver was killed in the crash. So cross slopes are critical. Drainage. I apologize, this is an old slide, but I like it. I can't find a newer slide that shows it. this concept. And I don't know if this is design or construction, but notice the inlet here is not at the low point of this sag curve. So every time there's significant rain, this fills up with water. And during warmer weather months, like we see here, this could be a hydroplaning potential. But in some climates in the northern United States, in the wintertime, this water could freeze and create an isolated ice patch. Temporary traffic control, an area primed for lawsuits. We have changed conditions, maybe a lane closure or a traffic shift. Maybe the pavement surface has been milled, so it's not the same surface that drivers are used to traveling on. We have a lot of devices. There may be equipment close to the road, all sorts of things that can create conflicts and problems and ultimately lawsuits. Signing is one. Pavement markings. And look at this. This is sort of a mess in the daytime. Imagine trying to navigate that at night or in the rain. And devices or lack thereof. This is the same project. And at the time of the crash that occurred here, these two drums were out of position. They were not present here. It was a nighttime crash. This will eventually be a third lane of traffic. This concrete here will be the base or the pad for the concrete median barrier that will soon be placed here. But a truck driver coming toward us in this left scene, and this is there's two work zones here. This work zone is ending, it's kind of in the background here, and a new work zone is beginning. And this is the back of the arrow board that is closing this right lane. And my experience indicates that, unfortunately, but these areas where you have sort of adjacent work zones is oftentimes one where crashes occur and then claims occur. But anyway, the truck driver moved to the left lane, but these are gone. And notice this was not called for in any plans, but this portable barrier section was just placed here. And the truck driver claimed that he thought that meant he was supposed to go further to the left. So he actually ended up on the concrete pad here, and there were no type 3 or other barricades here, and it was at night. And you can see by the time he realized that he ran out of road, that it was too late to stop. The truck ended up in the river. Fortunately, he survived, but he did suffer a serious spinal cord injury. And a jury awarded him, I think, about $300,000 in a jury trial against the contractor. Even sidewalk work zone. Someone asked, I think, on Tuesday, do we need to consider all users? And the answer is yes, we do. Imagine this. I mean, I'm a sighted, able-bodied person, but this was a little confusing to me to find my way through there. Imagine if someone was legally blind or had a vision impairment, and imagine I'm in a wheelchair. This is essentially sort of pea gravel here, so it's not even an accessible route for someone in a wheelchair to get from this sidewalk to the crosswalk here. So maybe this whole section of sidewalk here should have been closed to allow someone to cross the other side of the street at the other end of the block. Traffic control devices, of course. Non-compliant regulatory signs, warning signs, and it's surprising to me that there's, maybe I shouldn't be surprised, there's personal injury attorneys around the country that can quote the MUTCD better than traffic engineers. So they are familiar with the standards of care, and many of them are aware of what's a standard sign and what isn't. Sign maintenance is important, including, notice these chevrons, they're actually in good shape. The sheeting is great actually on all of them, but notice this one, the sign has been bent a little bit or twisted, and just being out of alignment creates a dead sign. So that sign is really not visible at night. So for our sign crews, for example, or inspectors, we need to make sure they're aware of the requirements for sheeting and retroreflectivity, but also be on the lookout for signs that are out of alignment or out of position. Sign retroreflectivity, of course, there are criteria in the 2009 edition of the MUTCD, quantitative criteria for retroreflectivity, and we do need to manage and assess our signs. I get related to that too. I was talking recently to one of the vendors, one of the companies that sells the retroreflectometer guns for measuring sign retroreflectivity. He was telling me his company has sold more of those retroreflectometers to law firms than to roadway agencies. So again, that's sort of a sign of the times we're in, unfortunately. But the legal profession is aware of those requirements, and so we need to make sure we're aware of those as well, and make sure we do assess or manage our sign retro. And then not only the sign design and the sign face, but the sign supports need to be crash-worthy. And for example, this steel pipe is not a crash-worthy sign support. The roadside as well is something we need to look at. Maybe we need guardrail. That's certainly a non-recoverable slope there, and it looks like a significant water body at the bottom, which would pose a drowning hazard. So we may want to consider a guardrail here, or barrier of some sort. And if we install barrier or guardrail, we need to make sure we do it according to the criteria. And here there's a number of issues, including maybe the post spacing, this double rail here. Notice this non-standard end treatment. These end treatments are, maybe some of you have seen the videos or photographs. If a vehicle runs into this, that end treatment is like a knife blade. It will just go through a vehicle and slice up the vehicle and whatever is inside. So we do need to be attentive to the guardrail or barrier end treatments.
Ron, I'm going to jump in real quick here.
Sure.
I know one thing we've been working on is getting the information out about the turn down guardrail ends, and that they're not to be used on, routes, I believe, over 45 miles an hour, if I'm correct.
That's right.
Yep.
Yeah,
so because that's been a continuing issue. So we actually call it our RON updates, not after yourself, but it's a short for route of navigation. and I'll send that out to everybody afterwards, that they can look that over. But guardrail can do more harm than good if you have the wrong one out there.
That's right. Yeah, and I hate to mention it, but I've had 3, I guess, in my career. And notice here, it's hard to tell where this is, but it looks like it's in maybe a suburban or semi-residential area. So there may very well be pedestrians and children and young people on bikes and things here. I think I've had 3 cases in my career where a child has fallen face first into one of these ends like you see here, this exposed end. And I mean, talk about a sympathy factor where someone's sort of disfigured for life. There's a very high sympathy factor there, and usually it's not a good result for the road agency. So not only vehicles, but even think about young people or pedestrians or bicyclists who may encounter those ends as well. Also on the roadside, we have fixed objects. Of course, in the United States, the most frequently struck are trees. And trees are tough, right? I mean, this probably should be removed from a safety perspective, but maybe the public won't allow us to remove that for whatever reason. And notice this one, it looks like it's been struck before. And so if there was serious injury or death with this more recent strike down here, that plaintiff can argue notice, you were on notice. Maybe in this one, maybe at least we could put some sort of reflective tape around the trunk or something to at least make it visible to motorists at night. But this is a tough problem. I acknowledge that. And then we can't forget the stumps. Unfortunately, I see this quite a bit too, where agency did cut down the trees, but this stump more than 4 inches high, or all of these stumps here, are still fixed object hazards that can cause a vehicle to flip or to rotate. And so need to make sure we don't have stumps left. Second most frequently struck object in the United States is utility poles. This to me is particularly noteworthy here because notice there's no edge line really. The pole is maybe a slightly raised curve there, but at night, I think it's really tough to detect the edge of the road versus where the pole is. And I won't say where I took this, but I mean, this also troubles me. I realize this is temporary. These poles are going to be removed, but until they're removed, I mean, think about it at night, they're not even really marked. I think that's just yellow caution tape. It's not reflective tape. So at least mark them or put a drum in front of them or something to make them visible. And then sometimes you just have to scratch your head and wonder what people were thinking. Why would you put the pole outside the face of the guardrail rather than behind it? Pedestrian facilities. People are walking more these days. We're talking about active transportation, and so we need to pay attention to pedestrian facilities. This, I read recently, this is the most common cause of tort claims against public works departments around the United States. These heaved up sidewalk slabs that may trip an able-bodied pedestrian. Older person may fracture a collarbone or a hip or something like that and then file a tort claim. But this would be another example of both a tort claim and a potential ADA claim, because the way this sidewalk slab is heaved up, it appears that this would be inaccessible to someone in a wheelchair, perhaps someone using braces or a walker. So this is another one of those sort of double jeopardy type of cases on the sidewalk where an agency could be exposed to both a tort claim and a civil rights claim. This, I think, is at the courthouse or a library of a larger city. I'm sure the architect intended to do a good job, add some color and texture to the situation, but maybe they forgot they were in, I think this is in northern Pennsylvania, where you have a lot of snow and chloride chemicals and freeze-thaw cycles. And now we have, to me, a serious safety hazard for pedestrians. Actually, this is in my city, Morgantown, West Virginia. You can tell from the vehicles, this is a fairly old picture, but I like it. The reason I like it, and I say that sort of tongue in cheek, is because this is not a public works project. This is a private project. There's a building over here that you can't see, and it's having a new facade put on it. But the building you can't see is, at the time, I think it was the largest personal injury law firm in Morgantown. And I had to chuckle because I thought this agency has probably sued public works agencies around the state for work zones and things, but notice the quality of work for this particular location. I mean, all sorts of exposed hazards. It's hard to see, but there's a gas valve sticking up here, kind of camouflaged in the stone. Certainly not accessible from an Americans with Disabilities Act standpoint. So, but we do need to be attentive to those aspects. Gaps and grates and openings can trap wheelchair wheels or canes or crutches or bicycles. So if possible, these should be outside the travel way. If they are in the travel way, they need to comply with the ADA requirements in terms of size of opening. And this, I'm not sure this is a tort claim, but this is certainly, to me, probably a potential ADA claim. Notice this push button is really inaccessible to someone with a disability, given where it's placed. Maintenance, another prime area for tort claims. Drainage, this could turn into an isolated ice patch during the winter months. Clogged inlet. Driveways. You may see this throughout the rest of my presentation. These are often a source of drainage problems. Notice here the water originates on private property, flows onto the driveway, and then out onto the state road. In this case, this was the scene of a fatal crash. It was water during the day, but turned to ice at night. Vehicle went off the road and I think hit the tree back there in the distance. Shoulders. Shoulder maintenance is important. Another issue that sort of a pet peeve of mine is these high shoulder conditions where the shoulder, usually it's turf or grass, is higher than the pavement such that water cannot flow off the pavement onto the shoulder. So now here we have a potential hydroplaning situation because the right tires might be on the water, the left tires be on normal pavement, or in the wintertime, this could create a partially icy condition across the roadway. And even liability considerations aside, if you think about it, just think in terms of our investment in our infrastructure, you can tell what's going to happen here. This water is going to saturate the subgrade, weaken it, and eventually this edge is going to start cracking and deteriorating, and we'll have to do some significant reconstruction work there. So we do need to be on the lookout in maintenance for high shoulders. Talked about edge of pavement drop-offs. I think generally around the country, sort of the tolerable drop-off would be 3 inches, which this is much more than 3 inches. I'm aware some states, I believe, have a standard of 2 inches, which is fine. But I think nationally, probably about 3. You wouldn't want to have one more than 3 inches. This is probably in the gray area. This is maybe 2 to 3 inches edge of pavement drop-off. Vegetation management, at least in this part of the country where Victoria and I are, this time of year, the vegetation is almost at its full growth and it can block sight lines, can block signs, something we need to be attentive to in terms of vegetation management. And then there's a whole category of cases, legal cases, called hazard trees. And I'm not talking about this little branch here that fell down. This is kind of like our Joe and Sally icebreaker exercise that we did yesterday. But these trees, they may drop bigger limbs that could fall, or the trees themselves could fall onto vehicles. And actually in our case studies, probably next Thursday, a week from today, we will look at a hazard tree case. And these are always interesting and usually complex. Here's one from Pennsylvania. This was a fatal crash. The tree fell, you can see right on the driver front seat portion of the passenger compartment. And apparently this tree did have some health issues. Winter maintenance, usually a general snow and ice, those are immune. So a plaintiff can't typically claim, well, I slid off the road and overturned like this vehicle because the agency wasn't timely with its snow fighting operations, with plowing and salting. Usually those cases are immune. But cases that can occur and do occur during the winter, a lot relate to isolated icing conditions. This is a Pennsylvania case. This is an unpermitted, I guess you could say an illegal driveway for a timbering operation here. And notice no attention paid to drainage, so the water just flowed across the road here, froze, and this vehicle lost control, overturned. The female passenger is now a quadriplegic. And here the defendants were not only the road agency, but the property owner as well as the firm that was doing the timbering operation. I mentioned earlier bleeding pavement. It's an excess of asphalt at the surface. In this dry state, it's typically not an issue, but when it gets wet, this can be as slippery as ice or snow. And it's really a problem in areas of high friction demand like we might have here. Drivers are probably slowing down for this curve and then negotiating the curve, and so they do need friction. So this could be an issue here. Loose materials, especially for our two-wheeled road users, bikes and motorcycles. Pavement surface condition, rutting that traps water or ponds water. This, I think, is from Washington State, I'm not sure where, from those of us that are joining us from Washington State, but this is one of those combination of conditions. Notice it's a steep downgrade, sharp curve, there's a traffic signal here, so the motorists may have to stop. And I like what they've done here. This is an application of the high friction surface treatment on this curve and grade to enhance the friction properties of the pavement because there is high friction demand there. And Victoria, are we getting close to time I need to wrap it up?
Yeah, we're right at 3:30, and we do have one question, but I'm going to defer it till you start on Tuesday because it's kind of long.
Okay, you'll send it to me?
Yes, I sure will, and that way Val will still get the answer.
So thank you, everyone. We'll continue this and then get into risk management on next Tuesday.
Absolutely. Thanks for your attendance today, and we look forward to having you on the webinar next Tuesday. Thanks, Ron.
Thank you all.